There are various heads of damage in contract law, under which an amount can be claimed to reflect different types of loss. These include reliance loss, discomfort or disappointment, inconvenience, diminution of future prospects, speculative damages and liquidated damages. Where it is difficult to quantify the position the claimant would have been in had the contract been performed, it may be possible to recover expenses incurred in reliance of the contract. For example, in Anglia TV vs Reed 1971, it was difficult to predict how much profit would be made by Anglia TV when it was forced to abandon the production of the play, due to Oliver Reed's breach of contract. They were able to state how much expenditure they had incurred in reliance of the performance of the contract. Damages to reflect discomfort and disappointment can only be claimed where enjoyment was part of the bargain of the contract. For example, holidays or a meal out or entertainment. This is most commonly seen in holidays which fail to meet the standard the holidaymaker was led to believe would be enjoyed. This was established in Jarvis v Swan Tours 1972, where Mr. Jarvis booked a 15-day skiing holiday over the Christmas period with Swan Tours. The brochure in which the holiday was advertised made several claims about the provision of enjoyment relating to house parties, a friendly welcome from an English-speaking hotel owner, a variety of ski runs, afternoon tea and cakes. Many of these either did not go ahead or were not as described. Where the claimant has been put to physical inconvenience, rather than anger or disappointment that the defendant has not met his contractual obligation, the court may award a sum to reflect such inconvenience. In Bailey v Bullock 1950, the claimant was able to claim for the inconvenience of having to move in with his in-laws when his solicitor failed to secure his conveyance. Where a breach of contract adversely affects the claimant's future prospects, a sum can be awarded to reflect the loss. For example, a contract promising training and qualifications. In Dunk v George Waller 1970, the claimant had been wrongfully dismissed from a 4-year apprenticeship as an engineer. He was entitled not only to his wages for the remainder of the contractually agreed period, but also a sum to reflect his lack of training and the loss of opportunities that the completion of the contract would confer. Contract law allows damages for loss of a chance. This can be seen in Chaplin v Hicks 1911. The claimant was an actress. She entered a beauty contest organized by Hicks. Hicks was a famous actor and theater manager and advertised the contest in a newspaper. The readers of the newspaper were to vote and the top 50 would be invited to an interview where 12 would be selected for employment. The claimant got through to the final, but did not receive her invitation for interview until it was too late to attend. She brought an action based on her loss of a chance of gaining employment. She was awarded £100. She was entitled to recover damages for her loss of a chance of gaining employment. She did not have to demonstrate that she would have been successful at interview. Parties to a contract may legitimately agree the amount of damages to be paid in the event of a breach and provide for this in their contract terms. This provides certainty to each party so that they know exactly what they are liable to pay, should they be unable to perform their obligations. Such a clause will be enforceable by the courts, only insofar as it is a genuine pre-estimate of loss. If it is a genuine pre-estimate, it is known as a liquidated damages clause. If, however, the amount specified in the contract is not a genuine pre-estimate but is aimed at deterring a breach of contract or punishing the party in breach, this is known as a penalty clause which is not enforceable. This position was established in Dunlop v New Garage 1915, where the House of Lords held that a clause specifying a sum was payable in the event of a garage selling tyres below the list price amounted to a liquidated damages clause. In summary, contract law damages seek to put the parties in the position they would be in had the contract been performed. The claimant may be able to recover sums to reflect reliance loss, discomfort or disappointment where enjoyment was part of the bargain of the contract, inconvenience and diminution of future prospects. Speculative damages may be claimed. Liquidated damages clauses are enforceable, whereas penalty clauses are not. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.